I recognize that the Federalist Society is composed of really two different groups of people. Maybe there's even others in the group, in the Federalist Society, but there are, as we know, what we call conservatives and libertarians. And it is the wonder of the Federalist Society that both groups, even though they often disagree on specific issues, do agree on the basic function of the Constitution and the importance of the Constitution. And I will speak today about my understanding of the Constitution and where the courts have gone away from their responsibility to enforce the Constitution. Before I get to specific, more recent cases that affect us all, and that is the purpose of my book and my talk as well, which is a very, very practical approach to the meaning of the Constitution and what the judges have done to the Constitution. It was written for laymen as well as lawyers, and therefore it does try to be simple rather than engage in some of the theoretical discussions that do occur. I want to, at the beginning, examine one Supreme Court decision on which I would be surprised if anyone here would disagree with me that it was incorrectly decided. And by here, by the way, I would include the whole student body. That you would agree with me that it was incorrectly decided because it represented activist justices substituting their personal views for what the Constitution mandated. Let's go back to 1868. 14th Amendment was added to the Constitution, prohibiting all states from, and I quote, enforcing any law which shall deny to any person the equal protection of the laws. As all of you know, that was adopted to ensure that newly freed blacks have the same rights as whites. Despite those clear words, Louisiana arrested and convicted Homer Plessy, 7/8 white and 1/8 black, for violating the state law that denied blacks the right to ride in railway coaches reserved to whites. When reviewed by the Supreme Court, the 7-justice majority admitted, and I quote, that the object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law. Yet they upheld the statute and the conviction. They upheld the conviction. Now, how did that happen? Very simply, these justices substituted their personal bias of keeping blacks separate from whites for what the Constitution's words and intent required. Now, some today would cast aside this sorry example as different from other examples where they happen to agree with the bias that caused justices to depart from the Constitution. My book is an attempt to show that either the Constitution controls or there is no control over justices who simply mandate their personal views. Why did I write the book? I wrote it because I, like I assume most of us, love this country. My book spotlights the unique gift that our founding fathers gave to us, a written Constitution that was intended to guarantee that this country would be forever governed by the rule of law, not the rule of men, which was the term used then. Today I would say the rule of men or women. Now, the rule of law is not an empty phrase that simply sounds good. World history, as we know, has been full of autocrats and tyrants who ruled on the basis of their own bias, prejudice, and self-interest. And that allowed the haves to prevent underclasses from moving up and crowding out those already there. Our written Constitution, and it was written, which is very important, And the checks and balances it created were intended to prevent that from happening. And while, granted, not perfect, the checks and balances have worked pretty well, with Congress checking the President checking the Congress, and the courts checking both the President and the Congress, and all of us, the people, through elections, also check Congress and the President. But, as we know, there is nothing similar with regard to the third branch of government, the courts, and especially the Supreme Court, that, as my book details, can have a very substantial impact on all Americans' rights, security, and values, and yet is not subject to any check or balancing by other branches of government, nor subject to being ousted in an election. And yet our country's founders intended that the rule of law, not the rule of men or women, would govern Supreme Court justices as well as the President and Congress. I assume, and anybody can correct me by raising his or her hand, that we all believe in the rule of law. Anybody who doesn't? Oh, it's unanimous. So what does the rule of law mean as applied to justices? It means that they should not decide cases based on their personal views, on the personal views of those who happen to be wearing robes, but on what is in the Constitution and what our Constitution's authors intended by the words they used in the Constitution. Thus, justices must uphold laws enacted by legislatures that do not violate the Constitution, whether or not the individual justice approves the law. And likewise, they must declare unconstitutional those laws that violate the Constitution, no matter that they personally like the law. Our founding fathers expressly stated what they believed the rule of law meant to our judges. Alexander Hamilton wrote in the Federalist Papers, which we all know is the Bible of what they intended by the Constitution. He wrote that judges were not to, and I quote, substitute their own pleasure to the constitutional intentions, and to avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents. Now, I'm going to discuss a few examples out of many in my book in which I show that a scant majority, often only 5, of the justices have substituted their personal views for what our founding fathers intended, often doing a 180-degree turn-away from prior decisions of that same court, although the Constitution, of course, remained unchanged. Let's first look at one objective of government that can affect all people. Our governments, local, state, and federal, have the responsibility to go after and jail those who have committed crimes endangering people, such as murder, rape, assault, etc. My book shows that a Supreme Court majority has, without any basis in the Constitution, imposed burdens on law enforcement that the Constitution does not require, and that up until recent decades, the Supreme Court itself had rejected. I want to start by having you assume the role of appellate judges. I want you to consider this following fact situation. The defendant and the deceased were seen quarreling, following which a shot was fired, killing the deceased. Hours later, the police arrested the defendant in his boarding house room. They asked him if he owned a gun. He responded yes. Asked where it was, he directed the police to the washing machine, and lo and behold, it was found there. Ballistic tests established the gun fired the fatal shot. A jury convicted the defendant. No one, not even defense counsel, questioned that the defendant was guilty of murder. Based on these facts, do you believe that that defendant should be released and allowed, and the conviction set aside? Anybody who does, please raise your hand. No, the answer is, if you're going to be realistic, he should not be freed. Then why, without questioning his guilt, did the Supreme Court free this undisputed murderer? The answer is, you may guess, no Miranda warning was given before the defendant was asked if he owned a gun. The Miranda decision, by a 5-4 vote out of the blue, mandated a specific litany to be read to a person in custody, including, as you know, right to remain silent, have a lawyer, etc., before being questioned. Most telling in the Miranda decision was that if the litany was not given, what the defendant said was excluded from evidence, no matter that the circumstances established that the confession was voluntarily given. Nothing, as you probably recognize, nothing in the Constitution required this litany. All that the Fifth Amendment prescribes is that the confession to be used may not be compelled. It does not prohibit a person in custody from voluntarily giving a confession. And you may not know, Miranda was not the first time the Supreme Court had been asked to create a litany before a person could provide a confession. But each time before, the Supreme Court had rejected the idea. Each time they pointed out that the Constitution prohibits only a compelled confession, requiring the jury or judge to consider all of the circumstances, not any predetermined formula. So what was the effect of the Miranda rule on law enforcement? And although I have experience as both a prosecutor and as a defense counsel, and so I recognize it myself, don't take my view. Take the view of the Supreme Court itself. The court recognized that this Miranda exclusionary rule, and I quote, imposes a substantial cost on the societal interest in law enforcement by its proscription of what is concededly relevant evidence, unquote. So, contrary to over 150 years of court decisions, and without any words in the Constitution requiring it, 5 persons who happen to be wearing robes created a rule that allows criminals to go free. Now, another important tool of law enforcement is physical evidence of guilt that police may have uncovered. A dead body, a revolver, all of which that tests established was the murder weapon, for example. And such evidence, if connected to the defendant by being in defendant's possession or bearing defendant's fingerprints, you have to recognize is independent and extremely convincing evidence of guilt. The reliability of such evidence does not depend on whether the police officers did or did not first obtain a warrant from a judge. So let me give you a second fact situation for you to consider. Powell was convicted in state court of murder on evidence that included his possession of a revolver seized by police when he was arrested without a warrant on a vagrancy charge 10 hours after the murder, plus expert testimony that the seized gun had killed the victim. The Supreme Court set aside the conviction because, they said, the officer lacked probable cause to arrest Powell. The seized evidence was therefore excludable, and there was not sufficient evidence to try him. Where did a Supreme Court majority find the rule that the results of a search, obviously relevant and trustworthy, should be excluded? Again, the answer is they simply created it out of whole cloth. The Fourth Amendment, asserted to be the basis, has only 54 words in it. none of which provides that evidence obtained without a warrant must be excluded. Indeed, as I'm sure you know, the amendment doesn't even require a warrant for police to perform a search or seize evidence. Justice Benjamin Cardozo, hardly a slouch as a protector of civil liberties, succinctly said it well when he said the criminal should not go free because the constable has blundered. So you may, however, pose an appropriate question. How otherwise does society punish policemen who invade innocent people's homes? Well, my first answer to that is you're not punishing the policeman, you're punishing society by allowing a criminal to be released to repeat his crime on some other innocent person. Moreover, the irony of the exclusionary rule is that it is useless when police invade an innocent person's home and seize personal effects. In such a situation, the exclusionary rule does not apply because no case is brought against an innocent person. The consequence of the exclusionary rule, again, I quote the Supreme Court itself. I quote, "The rule of exclusion of unquestionable evidence establishing guilt results in the escape of guilty persons," unquote. I add to that statement and allows him or her to go out and commit more crimes. Now I'll turn now to another subject area, the effect of the First Amendment on pornography and computer games. One of the most ignored historical facts is that our founding fathers and the Supreme Court for many years after considered the protection and enhancement of morality as one purpose our Constitution fixed for our government and country. In recent decades, however, a majority in the Supreme Court has retreated from that view to substitute their personal elitist view of almost anything goes. Let's take pornography as an example. I'm not going to nauseate you with details of the rapes and murders that have immediately followed viewing pornography. In one, a horrible crime detailed in my book, but I won't detail here, an expert for the defendant testified that he committed as many as 24 rapes. And the defendant's lawyer gave the cause of his client's conduct, and I quote, "extensive viewing of rape pornography," unquote. Now, even before the 20th century, the Supreme Court rejected any conflict between statutes barring pornography and the First Amendment. Pornography statutes, the courts explained, were valid because they prevented, and I quote, "distribution of matter deemed injurious to the public morals." Even Justice Brennan, who we all know as a liberal defender of the First Amendment, wrote a court opinion explaining that, and I quote, "obscenity is not protected by the freedoms of speech and the press," unquote. The reason? Because a unanimous, hard to get a unanimous court, a unanimous Supreme Court mandated two requirements for First Amendment protection. They must be ideas that have a social value as a step to truth, and their value must not be outweighed by the social interest in order and morality. I think we can all agree that pornography hardly can be considered as meeting that standard. Criminalizing pornography had a long history embedded in our country's laws. Laws banning obscenity existed in each colony when they became states, and so too thereafter when each state was added to the Union. And the Supreme Court essentially copied the English case law on what is banned obscenity. I quote, "The test of obscenity is whether the tendency of the matter is to deprave and corrupt those whose minds are open to such immoral influences, unquote, which the Supreme Court further described in a later Supreme Court opinion to mean the young and inexperienced. So after almost 2 centuries of enunciating this rule of law, and with no change in the First Amendment, a majority of justices suddenly repudiated it. Most devastating to prosecution of pornography was the court's decision that even the presence of explicit sex, no matter how lewd and lascivious, is not obscene as long as it is exhibited, and I quote, in a manner that advocates ideas or has any other form of social importance, unquote. What in the world do those terms mean in practical effect? The effect is that a hardcore pornographic movie can be distributed if it is titled, for example, Understanding Why Pornography Can Be Harmful, and add a preface on the harmful impact of pornography, and then it can meet the court's emasculated standard of whatever you show is okay because it advocates an idea. I want to give you one interesting example of the extreme to which some justices went to legitimate pornography. Justice William Douglas regularly sought to allow pornography. In one case, in which he dissented, I'm happy to say, involving what I will quote, a sexual autobiography detailing with complete candor the author's sexual experience from age 3 to age 36. Douglas relied on a statement by the Reverend George von Hilsheimer, a Baptist minister. In his opinion, Douglas extolled von Hilsheimer as having, and I quote, extensive experience as a group counselor, lecturer, and family counselor, unquote. Douglas quoted von Hilsheimer as using, and I quote, Douglas is quoting of von Hilsheimer, the book insistently in my pastoral counseling was used by me and in my formal psychological counseling because it provides the history of a woman who has had sexual adventures outside the normally accepted bounds of marriage, and therefore gives the women to whom I gave the book at least a sense that their own experiences are not unusual, and that they themselves should not feel guilty because of their sexual activities, unquote. Calling this expert testimony, Douglas concluded in dissenting, quote, I would think the Baptist minister's evaluation would be enough to satisfy the court's test that the book is not obscene. What Douglas, to give him credit, I am sure did not know, as Google now allows me and you to know, von Hilsheimer plied women with this book to aid in fulfilling his own sexual desires. Women who attended his school testified that he, quote, was a violent sexual predator, a serial rapist, and a pedophile who raped and brutalized countless underage women students, as well as some staff women. Florida, the statute of limitations had passed on criminal prosecution, but Florida, because of his conduct, revoked his license to practice psychology. The pro-pornographic justice's reliance on such an expert says much about the merits of their position. Now, another area that I want to discuss with you, in which a Supreme Court majority has substituted its own view of anything goes for centuries of contrary decisions without any change in the Constitution, involves child pornography. For essentially 2 centuries, the court was unanimous that child pornography was verboten. Even Justices Brennan and Marshall, 2 of the most liberal justices on the court, agreed, and I quote, the state has a special interest in protecting the well-being of our youth that affords the state the leeway to regulate pornographic material, unquote. No one disputes congressional findings that child pornography is harmful to children, and that aside from the effect on the children involved in the movie, the greatest harm is on other children who are shown them. An expert panel reported, and I quote, "Child pornography is often used as part of a method of seducing child victims because a child who is reluctant to engage in sexually explicit photos can sometimes be convinced by viewing other children having fun participating in the activity," unquote. Yet, in 2002, a 6-justice majority held unconstitutional a federal statute that banned virtual child pornography, which is using modern technology to create sexually explicit images that appear to depict minors in lewd and obscene activities. I want to share with you 2 reasons the majority gave for asserting that they knew better than the hundreds of congressmen and senators and the president who believed the statute was needed to protect our youth. First, these justices argued that it's not so terrible that these pictures showed, quote, what appear to be 17-year-olds engaging in sexually explicit activity, unquote. Why, they said? Because, and I quote, "it is undeniable that some youths engage in sexual activity before the legal age, either on their own inclination or because they are victims of sexual abuse," unquote. Thus, these justices denied to Congress the right to try to lift the standards practiced by some young people. And here's the second reason these justices gave: because some movies made in Hollywood have portrayed teenage sex. I suggest to you that it is a sorry day that our courts look to Hollywood for the controlling standard. Now, I'll now turn to my last example of the anything goes mentality of a majority of the Supreme Court, which is violent video games for minors. What do you think of marketing to minors a video game that induces a minor to, and I quote some of the titles, take on the identity and reenact the killings carried out by the perpetrators of the murders at Columbine High School and Virginia Tech, or allowing a minor to rape a mother and her daughters, rape Native American women, engage in ethnic cleansing, fire a rifle shot into the head of President Kennedy as his motorcade passes by the Texas School Book Depository. California enacted legislation that made it a crime to sell such video games to minors without parental permission. A majority of Supreme Court justices struck down the statute as unconstitutional on First Amendment grounds. Ask yourself, how do such games provide the standard the Supreme Court had set, social value as a step to truth, by having children watch those games? Now, these few examples that I have mentioned are just a sampling of the many areas in which the Supreme Court majority has ignored the Constitution and usurped legislative powers that I fully document in my book. Other areas, which I don't have the time to go into unless I'm asked a question about them, include the banning of God, legalizing abortion, rejecting most death penalties, rejecting certain prison term lengths, allowing profanity on the public airways, allowing disgusting, really disgusting animal cruelty movies. And I, as a dog lover, really got nauseated in seeing what they involved. And even usurping Congress's role in dispersing taxpayer funds. I want to make something clear. As to all of these subjects, people in here and elsewhere can disagree, and I respect the right to disagree on the merits of any legislative action or inaction, the merits of abortion, the death penalty, pornography, and other issues. But the question I raise in my book and that I'm raising here, who should determine whether to allow, disallow, or regulate these actions? Should these decisions for our country be made by 5 individuals who happen to be Supreme Court justices, or by the thousands of elected representatives in Congress and state legislatures? Unless the words and intent of the Constitution clearly prohibit something, the Constitution left the issue to the people's representatives in the legislatures. Unfortunately, a majority of the Supreme Court has usurped that power. I therefore suggest that we all have the duty to make our voices heard when the next appointment to the court is made, to ensure that no one be confirmed who is unwilling to affirm his or her oath to enforce the Constitution and not render rulings on the basis of that justice's personal views of what the law should be because he disagrees with what the legislatures have said. I thank you for listening. I'm ready to take questions. Yes, sir.
I was wondering if you could maybe solve this inconsistency that I heard during your presentation, which was during the Fourth Amendment discussion you were talking about regarding the exclusionary rule. It seemed to be that you were saying because there's no remedy within the text, even though there is a right, the court was stepping outside its bounds, creating the exclusionary rule as the remedy. Contrast that with your discussion with the First Amendment, where there is a blanket prohibition on prohibiting speech, but yet you cite positively this theory of social value of the speech, which is outside the text. So it seems to me there's, at the very least, somewhat of an inconsistency in your position. I was hoping you could maybe solve my concerns.
I will try to solve your concerns. I can say I disagree with you that I'm inconsistent. But let me explain why. I will take the free speech First Amendment. What is in the Constitution are words that are clear, but have some question about what was meant. The writers of the Constitution and the Bill of Rights made clear in what they said, not only in what they said, but what they did at the same time, that they did not expect the words in the Bill of Rights to be absolute. They set them forth as rules, but to be applied as practically needed to protect society. At the time of the writing of the Bill of Rights and its adoption, nobody would have envisaged among the writers that, and I think you'll agree with me, that if somebody got up in, I guess they didn't have films at that time, but in a meeting where there were 100 people present and yelled fire when there wasn't fire, that would be allowed by the Bill of Rights, because technically you could say literally that it's free speech to say something in a meeting. But, and of course this is an extreme example, but it's the extreme example used by those who recognized that the absolute words are to be applied practically as needed to protect society. Now, Lincoln said it well in words that I won't quote, but you'll remember it when he said, are we to lose all our rights because we insist upon protecting one right? And that was the understanding of the authors of our Constitution. So And what I said as to how you should read the Constitution, I included that you have to look at what was the intent of the words. How is the intent determined? One is by Federalist Papers as an example of what they wrote, but the other is by looking at what the same people who wrote the Constitution enacted into law, or how they acted at that time. We know that, for example, when you look at the cruel and unusual punishment, which is another example, that was a phrase taken from an English rule. The English rule was created in order to prevent the repetition of the Stuart King's type of punishment, which included burning women at the stake and disemboweling men. And we know that although they used the phrase cruel and unusual punishment, they continued with the death penalty. Now, how could you reconcile finding that the words cruel and unusual punishment means no death penalty with the fact that it was not, that it was continued when they used the cruel and unusual punishment? So that you look at what they did, what they meant by the words. Now, you get to the last part of your, which was the first part of your question, which is both the exclusionary rule under both Miranda and under search and seizure. There are two ways of handling that question. First is, the rule was set forth in the Constitution, leaving it to Congress to determine the procedure to be used to enforce it. And if you remember your Miranda decision, the majority said, if Congress, which has the jurisdiction to determine how to enforce the rule against forced confessions, had adopted a procedure for enforcing it, then we would not have issued this ruling. That was a recognition that Congress had the responsibility. Now, the court, what was it, 4 or 6 years later, if you recall, Congress then, within 2 years, passed a statute, a criminal justice procedure statute, which basically returned to the pre-Miranda ruling about compelled confessions and how to determine for a jury, by a jury or a judge, whether it's compelled. Supreme Court then, when the case came to them as to whether that statute now ruled rather than the Miranda decision, the Supreme Court said, well, it's been in effect now for 6 years, I don't know whether 6 or 5, whatever. So we're not going to withdraw the Miranda decision. But that was going contrary to their own statement of what the law required, which was, what the Constitution required, which was that criminal justice procedure, which determines what should be allowed in evidence and what shouldn't be, was left to the legislature, left to Congress. So, I hope I've answered your question that my position is very consistent. It is on all parts of the Constitution, looking at what the Constitution says, its words, and determining what the authors and those who adopted it meant when they adopted it.
Can I do a quick follow-up?
Sure.
Well, so in the courts, at the time, there were courts of equity and there were courts of law, and we combined those in the U.S. One of the key principles of a court of equity is if there's a wrong, there needs to be a remedy. So it wouldn't strike me as being inconsistent, at least with the Constitution, for if there's no right on the case of an exclusionary rule type issue, for them to create a remedy, acting as a court of equity. So I guess my point would be, to me then, that's not really, that's keeping with the interpretation of the time, which is courts can in fact create remedies for rights when there are no express remedies.
I'm going to have to disagree with you on what a court of equity does. Court of equity, in my understanding, attempts to do equity and fairness, perhaps a synonym, for the parties before it, not to translate those judges' belief as to what would be best for society as a whole. That is left up to the legislature.
I want to add to his question a little bit.
Sure.
Because I think in the Fourth Amendment context, there is an argument that the remedy then is now effectively eviscerated. At that time, it was common, the point of a warrant was, because there was no public police force, if your house was searched, you could sue me afterwards, but if I had a warrant, that was my way out of the lawsuit, because I went to a judge and showed that there was probable cause that there was going to be evidence in your house. But now with a public police force, those lawsuits don't work out because there's now the sovereign immunity issue. Is that not the case?
No, sir. First of all, let me correct two, sorry to do that to you,
No, go ahead.
two parts of your hypothesis. First, having a warrant doesn't preclude a finding that the search was illegal and unconstitutional. One of the crazy, I use that term, parts of the administration of the Fourth Amendment is when a police officer goes to a judge and the police officer, acting in all good faith, says, here's my affidavit and here's the facts I have. And the judge finds that that establishes probable cause. And the policeman goes in and searches. Another court, a trial or an appellate court, is faced with the argument, the judge was wrong in finding that was probable cause. And another court or appellate court will, if that is so, set it aside. Now, whose fault was it? The policeman, if he had been told by the judge, all acting, I think, in good faith, had been told by the judge, you know, I think this isn't strong enough. You've got to have something more or else I won't give it. Policeman whose interest is in searching to find the evidence would either have come up with something more or wouldn't have done the search. So, but the results of the search in that circumstance are still excluded, even though everybody acted in good faith. That's item one. Item two to the part of you, there are remedies. Civil rights action. For somebody who you have the evidence, a policeman who goes in for bad faith reasons, he can be sued, and there have been cases where the policeman has been sued. So you have the remedies that are available. Are they easily available? Well, I'll tell you that in certain minority jurisdictions, I don't mean minority in the way the court acts, I mean minority where there are minorities if you take the Bronx, for example, for many years, the reality was that if somebody brought a federal deprivation of civil rights action, a jury would very often find for the plaintiff. And so that in those districts it was practical. Would it be practical maybe in some parts of the country? No. But it's there. But I get back to the real issue. Tell me how excluding evidence that is clearly reliable helps enforce the Fourth Amendment by deterring policemen from violating the Fourth Amendment. The policeman, sure, he wants to get a conviction, but it doesn't affect him. He will go out the next time and try to get the evidence no matter what. it does not deter a judge who thinks he's acting in good faith. And when you're dealing with Miranda, let me point out that before Miranda, compelled confessions, as I said, were inadmissible. So that if the evidence established that the policeman had figuratively or literally hit the defendant over the head to confess, the confession would be excluded. And there are many cases where it's excluded. So now you have Miranda. But let me continue with that. The policeman who was not honest would get on the witness stand and said, I didn't touch him at all. It's the lie that I hit him over the head. The policeman who was honest wouldn't have hit him over the head. Miranda, and if the policeman testified most places that he didn't hit him over the head, he'd be believed. So on the Miranda, what's the result of the exclusionary rule there? If a policeman is honest and says, oh my gosh, I forgot to read a Miranda, the confession is excluded. If the policeman is dishonest and says on the witness stand, I read a Miranda, the confession is admitted. How is that any different? And I'll give you one example of what I think is one of the most stupid decisions I've ever seen under Miranda. A 3-year-old girl disappeared from her home in, I forgot whether it was Ohio or Indiana, one of those two. And at about the same time, a young man of about 25 disappeared from the same house. The police found the young man across the border. And they sent somebody to bring him in. And while the one policeman was driving this 25-year-old back to site, the policeman didn't question him, but he made one comment. You know, the worst thing about this is that the parents feel miserable, that if their daughter is dead, they want her to have a Christian burial. That led the culprit to say, all right, I'll show you where the body is. So he takes the policeman to a wooded area, finds the body, brings him back with the body, and that evidence is excluded. Why? Because the policeman, in making that comment, didn't think he was questioning him and just didn't read Miranda. Now you tell me how that serves societal purposes. Yes, ma'am. And I apologize if I...
That's okay. That's all right. Regarding Miranda, I was just wondering, remember the Central Park jogger case and the Central Park 5 young men who were convicted and spent, I don't know, 10 or 15 years in prison before it was found out that it was somebody else who was the rapist? And I was wondering, do you know whether they were read their Miranda rights? I know that their confessions turned out to have been coerced. And I also understand in retroact, in hindsight, that those 5 confessions all conflicted with each other because they were all making things up because they hated the interrogation. So I just wondered if you had any comments on that.
There's a very good example you give of where Miranda doesn't really protect the innocent in any way. And I have to assume, I wasn't there, and I have to assume that what the police later found, or the law enforcement authorities found, that these were not the guilty young men. But it's a good example. Formalistically reading that litany doesn't help when the police are going to pressure you, assuming that was happening.
And I just want to add one other little thing. I've heard recently that there's discussion of maybe like videotaping police interrogations in order to make sure that they're not coercing people into what could be fake confessions.
There again, I'm opposed to videotaping requirement, although some places do it, I grant you. The reason I'm opposed to it is twofold. One, that doesn't stop the policeman 2 minutes before he turns on the camera. it becomes an unnecessary, it becomes an extra safeguard for the policeman who is not honest. But more than that, tell me, would you like to have everything you do and whatever work you do videotaped? Don't you think it would affect how well you perform your job? And policemen are human beings. And you can get some bad apples, sure, rotten apples, but most of them do their job properly. And to insist that they be videotaped in everything they do, every breath they take, is going to deter them from doing their job in a way that whenever they worry, oh, will this be misinterpreted? And
Okay, just on one more little thing I would
Sure,
like
go ahead.
to note. These new Google
you're just
glasses-
proving to me you listen to me.
Okay, yeah, the Google glasses seem to be another version of being continually videotaped. If you've heard of these Google glasses, I heard that they want to buy a couple done for the police department and have a couple there, somebody or other in the police department wear them. And basically, it would be as if somebody is seeing, somebody else is seeing everything you look at and everything you do, or something like that. I'm not exactly sure, but it sounds like 1980. It sounds very much Big Brother.
Sure, it certainly sounds like 1984.
Yeah.
But I haven't heard that, but if that's so, I would think it's wrong. The current stop and frisk issue in New York City, de Blasio and some of his people have suggested, well, we should have cameras on every policeman who's going to do a stop and frisk. To me, you start out then as a presumption that policemen are improper, acting improperly, and secondly, it has to affect. Are they going to stop as many people? No. But are they going to act then contrary to what their purpose is, and merely, how is this going to safeguard me personally? Yes, sir.
I agree with that. We should look at the original intent for the cruel and unusual punishments and for obscenity. My only concern is that when does it come to a point where our current notions of we've had our current changed notions of obscenity and changed notions of what it means to be cruel and unusual longer than we've ever had the original intent of those words, and will that ever factor in? For example, even if let's say 2016 we have a conservative president, Justice Ginsburg retires, and the court is once again more conservative. Do you think you'll ever go back?
Well, I'm glad you mentioned Justice Ginsburg, who happens to be a friend of mine, even though we disagree on most things. She's a very wonderful woman, and a very smart woman. And apropos, and I'll get back to directly answering your question, but apropos of what you said, I think she recently made a comment that really answers your question. She was not on the court at the time of Roe v. Wade, and she personally is in favor of pro-choice. But she said, and these are not her words but the substance, that she wished that it was such a controversial issue. It was not 5 justices who decided this, but that it was left up to the people's representatives in legislatures. That's what our Constitution envisaged. To the extent that you want to change something, there are 2 ways of doing it. One is if legislation by itself is sufficient, leave it up to the people's representatives who are closest to the pulse of what people think about morality or any other issue. But if the Constitution prohibits something that you want to allow now, do as was done with the injustice of not allowing women to vote after the 14th Amendment. You get an amendment to the Constitution. That procedure is there. And I have to say to you on morality, what worries me about the presumption in your question that it is good and should be accepted if the general view of what is moral has changed from the past.
Oh, I don't assume that at all.
Oh, you don't? Okay,
No.
because our founding fathers said for example, John Adams, the only foundation of a free constitution is pure virtue. George Washington, virtual morality is a necessary spring of popular government. Jefferson, even Jefferson, an essential ingredient of a civilized country is a political code with a chapter of morality. And we all know from our history that some of the strongest empires in the world, countries in the world, died, lost their power, lost their existence, after first having a tremendous drop in the morality climate.
I agree.
Well, if there there's one, sorry, go ahead.
Yeah, I'm just curious about the overall purpose of writing this book. What would you like to see happen? And I'm just trying to establish whether you're trying to do what I'm trying to do, and I'm trying to say the whole procedure of selecting judges is kind of crazy, that judges should be just graduates of, just regular college graduates with a degree in logic. And their business should be to examine two sets of argument, the argument of plaintiff, the argument of the defendant, determine which one is stronger, and award victory to the stronger party. Now, I do not know what you're trying to do, because right now, it seems to me, the judges are quote-unquote kings, and it's kind of an accepted fact. I just read about this in the New York Times, where judges refer to themselves as kings, and that's clearly, first of all,
Don't believe
incompatible.
everything you read in the New York Times.
Okay, so that is first of all, that is clearly incompatible with any notion of democracy. But second of all, is it your purpose to take the existing judges and they read your book and they cry and they say, I sinned, I decided case arbitrarily, I will no longer do that, I'm going to decide case logically, or whatever is your criteria, and or you just want to say, you know what, judge, you're not a king. And if you start acting like a king, we're going to drag you to the courtroom and we're going to, well, fine you, we're going to, whatever it is, kick you off the bench or whatever it is. So I'm just really trying to see if you try to reform persons and make them moral, or if you're just trying to reform the system and say the system has got to make it impossible for judge to swindle parties out of justice, as is happening now all over the place.
Well, it is frankly impossible to prevent miscarriages of justice. What you want to do is to have a system. Because, the reason I say that is because a judge is not a computer. You can't just feed into it and say, get out a totally objective answer. There's no such thing in a computer. Judges are human. They can make mistakes. But what I'm trying to do by this book is to try to awaken the American public to the fact that we have to be careful that our judges recognize their limited power, and it's limited by a written constitution, a constitution that was written just for the reason that our founders said, we don't want somebody just deciding on the bench what is fair or what they think is best.
But no matter what American public thinks about judges, judges think that they are all-powerful kings, and they gave themselves the right to, we've discussed it a little bit, to be quote-unquote corrupt and malicious, to substitute parties' argument with that. Well, that's Pearson v. Ray. To substitute parties' argument with either its exact opposite or with their own fantasies of what it is, even though those fantasies are totally factually inaccurate. And, well, that's case
yes,
law.
And just as they may say, if they were here right now, that you are misstating what they said, I'm not claiming you are, but so too judges, because they are human, can misunderstand and misstate. And that's why we have an appellate procedure to review it. Even the appellate judges can be wrong. But what I'm saying is, not that judges can ever be prevented in realistic terms from making mistakes, but that they have to realize that they are bound by the written Constitution. when they make decisions. Would I change our system? No, because there is no system other than a dictatorship, which you, using very good judgment, departed from, as some of my wife's relatives did the same thing, because we have here in this country at least an attempt to set up a procedure. The question is in emphasizing that the judges who decide that under that procedure, they are limited by what the procedure requires them to do.
But they aren't, that's the problem.
Well, they are in the end. Does it always work? No. But nothing always works.
But they themselves say that they aren't.
No,
That is
I will tell you, I will give you just one example. Justice Oliver Wendell Holmes, a great justice, had a case before him on the constitutionality of a statute. And he wrote the opinion which said, I think this statute is the craziest thing in the world. This is not his exact words, but a substance. And I wouldn't have adopted it if I was in the legislature. But that's not my job. That's the job of the legislature. And therefore, my job is merely to say, is it constitutional or not? It's stupid, but it's constitutional, and therefore I won't set it aside.
I sued a judge for exactly inverting the argument of my lawyer and saying, you know what, I deny you victory because your lawyer said the exact opposite of what he said. If he said what he said, I would have given you the victory, but because he said the opposite of what he said, and the decision was that the judge has the right to do it, that the judge has the right to violate procedure. For example, when the other party motions to dismiss the case, the judge is supposed to take your argument at its most, at its strongest and treat it as factually correct. The judge treats it as factually incorrect. That is also okay. So there are no
there will always be, and I am not expressing a view because I don't know the facts, there will always be mistakes made by humans, and judges are human.
Well, I do not know if those are mistakes or just deliberate, or, you know.
I have a problem in thinking that a judge, there was a judge by the name of Manton who took bribes to decide cases, and he obviously was intentionally selling himself. I doubt, no matter how right you may be, and I express no view on it, that the judges on your case, in the court that you are in, intentionally made mistakes that they thought were mistakes.
Well, how do you
So I
say
think
that something was not
if
said?
we have other questions.
Okay, yeah, go ahead. Oh, I'm sorry, I
Anybody
apologize.
else?
If
Yes,
anyone
sir.
has, yeah.
So I have one more. You seem to be expressing a very strong view of the legislator, but they seem to be in a very bad position, at the very least, to protect minority rights. And I don't mean minority in the sense of an ethnic minority, although that's a possibility. I just mean generally minority, maybe in the sense of the tyranny of the majority concept. And the Constitution does provide kind of open-ended protections, such as privileges and immunity, some of the rights we were talking about, even though they're not concrete. And you seem to be saying, if they're not really concrete rights, or if they're not really heavily detailed, we're going to leave it up to the legislator. But if you do that, because of public choice theory, you're going to have a legislator that's either captured by small interests or the tyranny of the majority.
I'm sorry if I gave you that impression. The legislature, and I thought I said specifically, if the legislature passes a law that's consistent with the Constitution, then the justice's obligation is to uphold the law. If they pass a law that is inconsistent with the Constitution and the intention of the Constitution, then it's the Supreme Court's judge's responsibility to set it aside. Privileges and immunities, the court has made clear what they are, in the sense of how you determine what they are. Were they privileges and immunities at the time of the enactment of the amendment? And they look to that. And they look to what was intended by it. Certainly, any legislature, and there have been legislatures that have done it, that violates the rights of someone because of color or religion, the Supreme Court or the court should strike down the law. But that's consistent. All that I was saying about leaving to the legislature, if the Constitution allows or doesn't allow, that is, it's neutral on it, then it's the legislature's obligation to decide. Death penalty is an example. Abortion is an example. The Constitution doesn't preclude or authorize abortion, but it's certainly, given the fact that every state, when the Constitution was adopted, when the Bill of Rights were adopted, and every state thereafter that came into being as a state, had laws against abortion. Now, legislature can change those laws in the state to say abortion should be allowed. It's within the Constitution, but there's nothing wrong with leaving it up to the legislature to decide.
So can I do a quick follow-up? So
Yes.
Take for instance the Second Amendment and the right to bear arms.
Yes.
There is at least ambiguity within the text, and possibly, I'm not making a historical claim here, possibly in the history of the Second Amendment of what it meant at the time. So how would a judge decide that when there's an ambiguity, even if the judge thinks, well, this is probably an individual right, but I'm not convinced because of the text? How would you think a judge should decide a situation like that?
Just as the Supreme Court justices did in Heller, the majority. They said, what did those words mean when it was adopted? And they said, at that time, every, women weren't considered, but every male, able-bodied male, was considered part of the militia. And for that reason, they expected every male to have his own gun. And there was no reason to believe that those words meant anything else but what was the actual experience of these people when they were adopting it. That's how you decide.
So you don't think there are any cases where, in the Constitution, where the clause truly is ambiguous, even looking at the historical record, and there might be like slightly ambiguous, and there's degrees of ambiguity, but in those cases where there is ambiguity in the text, how should a court approach it then? Should they defer to the legislator, or should they make a decision?
It depends if they read, and if a reasonable read of the Constitution is a prohibition or a requirement of allowance, then they do their best to interpret it that way, and that's the law. When they decide, or it's clear, that even that it was not intended as an absolute right, then they leave it up to the legislature to say, you want to make it a right, okay, or you want to not make it a right.
Okay.
Yes, sir.
Okay, I actually want to draw upon this question because this was part of my question as well, and that I don't actually believe that it's practical for anybody to separate wholly their personal views, their beliefs, their value system from any way of interpreting or reading a text in any sense. And I just maybe want to ask a question that, I don't know, maybe was on his mind a little bit more explicitly. And that is, so I don't think that any of these justices, at least on the Supreme Court, are kind of blatantly saying that my belief may be at odds with what the Constitution says or how I read the Constitution to say, and then I'm just going to choose my belief over that of the Constitution. I think that they're a little bit more clever than that, and at least they wouldn't come out and blatantly say it.
We did.
That they would, maybe in certain instances, right? But there are issues where you have different personal value systems from maybe another person, and you will come to two different conclusions. And I'm wondering, how can you possibly separate those when you're going to talk about these kinds of ambiguities? When you may read it a certain way to believe that your value system will lead you to this conclusion, and they're going to read it a certain way where their value system will lead them to another conclusion. And the only way that you can possibly say that they're wrong is because your values conflicted with theirs. I'm just wondering if you can comment
Well,
on how practical it is for
first
you
of
to
all,
separate these.
The example I gave of Oliver Wendell Holmes shows that you can separate. Secondly, in the book there are cases on the death penalty where a justice basically says, I have no doubt that this was, death penalty was allowed under cruel and unusual as what was intended, but I think my view as to what is cruel and unusual should decide it. Now, that's clear, expressing a total substitution of his or her own view. Human beings are obviously going to be colored to the extent that they can't control their emotions. We do it all the time, not only in reading the law, but in just how we live. But that's what we deal with human beings and their judges. And all we can ask is that they try their darndest to live by the Constitution. And I can only underline that to say, if we were to be ruled by what justices believe is the best for society, even in good faith, why did our forefathers battle so long about the words of a written Constitution when they could have said in one sentence, we will be governed in the future by 9 justices who will do the best they can to implement what they think is fair and just? It isn't. And so, you're right. Justices may make mistakes in what they think is the meaning of the Constitution. But at least if they start with the first premise, that it's not their views that govern, but what the Constitution says or was intended by its authors, they at least are trying to do the right thing. Will it work every time? No. But tell me, how many times have you, I won't ask you, but I know how many times I've said to myself, I gotta hold my temper when I'm very emotional or something like that. Do I succeed every time? No. Yes, sir. Somebody was back there.
Oh, actually, that's my question.
Oh, you were? Okay.
If it matters.
Did I? Yes, sir.
Anyone else who has one can ask, because I feel like I should be last in line.
Can I just?
Yeah, go ahead.
Yeah, I just have one more. So, and I'm going to make a lot of assumptions, and please feel free to correct them if
Sure.
you disagree. So, there's this notion that we have the different levels of the courts, and at the trial court level, there's a notion that courts are going to be more inclined to be able to do individualized justice between the parties that are in front of them. And then as you go up the chain, at least some justices believe that you're not looking to do individualized justice anymore. You're looking for a more broad societal principle. And so I can already see your blood pressure rising when I say that.
No, not my blood pressure. I understand what you're saying. I'm not sure it's always correct. It depends on if the issue in the case is going to be the facts as to how they're read.
Right, and I mean, at least in this day and age, a lot of the time, facts are becoming more and more important and relevant.
Yes.
But, so, you spent a lot of your talk focused on Miranda. And that's kind of and the examples that you cite, they seem to me that at least one person could say that all you're doing is talking about individualized justice and using these particular examples to incite some sort of emotion or outrage that the Supreme Court would hand out a decision that will then let this specific killer go free. And I'm wondering, so you seem to imply then that there's no societal good that can come out of these sorts of decisions. And I think you made it a little bit more explicit and later about specifically in the Miranda context. Do you think that's true of every context then?
No. I think you have to look at the context, but any context in which the Supreme Court decides that the Constitution requires something that it doesn't require would give, in my mind, a context that's contrary to what they're supposed to be doing. And that although they may view what they do as better for society, in the long run, if we are not governed by a Constitution, and individuals can decide what they please as to what is better, that's a very slippery slope to loss of freedom. It is, in the end, the Constitution that guarantees our freedom. So, sure, judges can be wrong, but if they're wrong in looking at it as they are supposed to look at it, that's human foibles. But if they're wrong by not looking at it as they should be looking at it, then that's violating their oath of office. Anybody else? Or yes, Vince.
Well, yeah, this might be a good ending question, actually. It's kind of draws from the whole discussion. So, and also this is a bit of a devil's advocate question, I should preface, but isn't it a little convenient that falling back on the original intent tends to match up with a lot of your policy preferences? That if the court stuck to the original intent, the results would tend to be what you want the court to be deciding. Are there results that come from the original intent where it disagrees with your policy preference? I finished over the summer Randy Barnett's book, Presumption of Liberty, and one thing I really appreciated is at the end of this theory, he says, a consistent theory always has some area that doesn't, if you're really consistent, there's going to be something that doesn't match up perfectly with what you want. And he shares an example of an area in the Constitution that he just thinks is deficient, but he'll accept because it fits in with his theory. So I'm curious if you could share something associated with the original intent of the Constitution that disagrees with your policy preference, and if you struggle for one, I am curious what you think of Brown versus Board of Ed, because there are a lot of originalists that have argued great result, but in reality, probably not what the 14th Amendment was intended for, and how you might reconcile that.
Well, you raise a very, very good question that I've never thought of. And I confess that in the 2 minutes that I have here left, I can't think of one.
Okay.
But as far as, and I confess that my tendency would be to state that, well, no, I'm going to give you one.
Yeah, please.
I think this Supreme Court was probably following the original intent, claimed that it was following the original intent, when it did not grant women the right to vote under the 14th Amendment. I read the 14th Amendment as saying that women should have been granted the right to vote. So there's a case where I think that the original intent, as found by the court, was contrary to what I believe. On Brown v. Board of Education, I do think that just as I used Plessy v. Ferguson as an example, that you can't have 14th Amendment applied literally and still prevent blacks from going into the same school as a white. And my problem with Brown v. Board of Education was not that bottom line decision that could have been written in 2 pages, but the 2 things that flowed from it. One, this Supreme Court deciding that it could look at sociological evidence which wasn't needed. And then secondly, its implementation, which I thought was ignored reality and which has resulted in the torpedoing of inner city schools as far as quality is concerned. The forced busing of blacks and whites in order to create a numerical equality was dead wrong. And was not required by the Constitution. All the Constitution required is that an individual who wanted to attend the school should be allowed to attend it. It certainly did not call for saying to whites, you can't attend the school you want to attend, you've got to be bused. And the result actually was the denuding of our public school system. So I hope I answered the question.
You did, and we'll end on that note.
Well, thank you all.
Thank you.